Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
Today we're going to respond to a viewer's question and go beyond that, dealing with conservatorships and hopefully how to avoid that issue.
Try to prevent them ahead of time.
A lot of things we do in law, certainly we attempt to avoid problems in the future, and conservatorship is a very important place for the law, and it's becoming very important to those of us born of my generation, because conservatorships, they're hard to do, and when I'm saying hard to do to a family member, hard to accept, but there's a very necessary purpose. Now, there are two kinds of conservatorships, right, Bob?
Yes, there's your general conservatorships, and then there, I see what you're talking about, the conservatorships of the person and then over the finances.
The estate.
The estate,
right.
Yeah.
Now,
there is another kind of conservatorship, but we're not going to talk about that.
We're not going to talk about that. This is one that we see most often.
Right.
Conservatorship of the estate. That's where the person may have all of their faculties, but the a conservator is appointed to supervise the financial affairs of the person who's found by the court to be incapable of doing so him or herself, to the extent that the property will be wasted unless there's somebody there to actually manage the property. So this is really just over the estate, and that could include checking accounts, the real estate, almost anything, correct?
Correct, and I know this is jumping way ahead, but I had a very interesting situation when I was a really young attorney, and that was where we actually had a jury trial over who was going to be the conservator of the estate.
You're jumping ahead.
Yeah.
But certainly there are all different kinds of rules that go into place when you're looking at conservatorships, but the bottom line is you're going to court for the court to appoint somebody as a conservator over the conservatee. Now, in the law, we get, and I do too, get hung up in this issue of whether it's conservatee, conservator, who's who, assignee, assignor, and many other E's and O's throughout the law. And I personally would rather use first names or something else to describe people, because you really get lost in who's who, especially if you've got a lot of different parties that are involved. But the purpose of the conservatorship of the estate is literally to run this person's financial and personal affairs, correct?
Correct. It's to prevent them from fraud, or say they're susceptible to sales, or they just in a position where they can't take care of their money for one reason or another, and it's able to be demonstrated.
And it may go into actually obtaining property, signing them up for some Social Security rights that they may have, administer, manage, protect, and dispose of real property and personal property, any benefits, income. They literally are running that person's life.
Absolutely. When you're dealing with the estate, though, they're running it only as to their the estate. The person can still make their personal decision, and you can have a conflict there, because say the person says, I want to live in that house, and the conservator says, of the estate says, no, I'm not going to pay for that.
Certainly you can get into a problem of, what kind of conservatorship is it? Is it a conservatorship of the estate or the person? And you're right. And it was just over the estate. The person may still be able to make individual decisions. And I've actually seen a case where there was a conservator of the estate and a different conservator of the person. And that caused some real friction issues, and needless to say, it ended up in court. Now, when you're talking about conservatorship of the person, now we're taking any decision-making process away from the conservator, the person who's under the conservatorship, correct?
Absolutely. There's a kind of a formal stated rule, but the basic thing is that the person's unable to take care of their food, clothing, or shelter.
And certainly
by a preponderance of the evidence.
Correct. Now that's the legal issue where we get into of what type of evidence is necessary. The lowest we see in criminal law, which is probable cause, and we work up the ladder, we get to preponderance. And probably the best way to describe it is if you had a total of 100 votes, you only need 50 plus 1. Just slightly more than 50, that's a preponderance. Then we go clear and convincing, and then certainly beyond that, as in the criminal law context, is proof beyond a reasonable doubt. But here, it's if the judge feels like I'm on the fence, but I'm slightly leaning this way or that, that's sufficient.
True, absolutely. I think I just make a note of that because in this type of case, it's really unusual because it's a civil case, but you're taking away somebody's rights, but it's still a civil proceeding, and therefore we have that civil burden of proof.
But the whole purpose is to protect somebody.
That's right. It depends on how you're looking at it, but you're right about that.
Certainly, if a person says, I don't want to be under a conservatorship of my person, I want to be able to make these decisions, the court can give limited rights to the person under the conservatorship, can they not?
Oh, not only that, the court is duty-bound to appoint a lawyer for this person. And that lawyer has to go out and talk to the proposed conservatee and find out how they feel about it and report back to the court and tell them if that person wants a jury trial or a court trial, they get it. You try to work it out, of course.
Right. Now, conservatorships are different than other areas of law. We know that in a civil action, everybody's got their attorneys and so forth, and the court kind of sits back and gives direction of where the case is going to go, and may at times even say that you haven't got a good case or something along that line. But in conservatorships, the court is actively involved by appointing, for instance, a probate referee or investigator to look at the facts, and they report directly to the court, correct?
Right, well, each county, particularly the larger counties, has a referee, and they report on every case, they report back to the court. And if there's disputes later on in the conservatorship, you could have private referees that are compensated out of the estate. But initially, there is, yes, an investigator, and he's like a referee type.
Right. But they're making recommendations, they're writing them up.
They write an actual report, a long report.
Right. The decision ultimately is with the court, but as I said, the court is far more involved in a conservatorship case than they are in any other cases I can think of in the law, except for maybe juvenile dependency cases. But conservatorships are really unique because you're taking away some very significant rights that a person has, whether it's their property or their person. And in today's world, we hear about dementia and Alzheimer's, and maybe it's a stroke that's caused some brain damage.
It could happen to a younger person, too.
I recently had a client that had a stroke at 21 years old. And fortunately, they had no they had no residual effects, no long-term effects. But we've got to protect people who are suffering from any disease or whatever is afflicting them, and this is the method in which to do it.
Right, right. And we have government agencies that assist in this, too.
Right. And so what the court is really doing is that the court authorizes the conservator, that's a person, and if I mix up the terms, I'll try to clarify them, but the person that's in charge of the conservatee basically authorize them to do certain things. And they can literally, from time to time, check on them and make sure things are being done appropriately, correct?
Yeah, that's correct. It's actually when the case is adjudicated or agreed or upon in court and orders issued, his powers are all laid out right there. And sometimes they're tailor-made to the particular situation.
In the most severe of cases, of course, the person that's running this other person's life or the conservatee's life, they're making some very significant decisions, and maybe that you've lived in a house all of your entire life. It may be subject to approval of the court to sell your home, to put you in a care facility. They have taken over your life.
Well, exactly. Somebody could be lived in their home for 50 years, and then that hard decision comes along. Is it safe for that person to remain in that home and still cook and use a stove? You know, is it safe for them? Is it safe for the neighbors? It's a very difficult decision, and sometimes you will go back to the court and see what the court thinks about it.
Another where conservatorships are very unusual in the law is that anybody can ask the court or petition the court for a conservatorship on anybody else.
Including yourself, right?
Well, you can literally say, yes, I need some help here. That's very rare the case that a person that's suffering actually does it themselves.
You don't see that, but it is an interesting quirk, yeah.
But whether it's a friend, a neighbor, somebody from Adult Protective Services may do it, but virtually almost anybody can petition the court to say to the court, this person needs a conservator. Now, they may not be saying, I need to be the conservator. They may just say, this person needs a conservator, whoever the court may appoint.
Right, and I usually see this arise in family situations with children and parents. That's where I have seen it the most. Or with some, but that's where I see it, without getting into great other detail.
And one of the things we're going to talk about is who's going to be the conservator? Who's going to be that person that's making the decisions? And when we talk about durable powers of attorney, you'll see that there, you drafting or having drafted out for you a durable power of attorney, you can actually tell the court, if I go under conservatorship, I want these people to be my conservator. Now, certainly the court has to agree with you, but you can certainly ask the court to strongly consider these individuals.
Now think about how important it was that Steve just said, because at some point in your life you may have the situation where you're going to need a conservator that's going to make all your decisions for you, and they're going to be enforceable. And at this point in your life, you have a say of who that's going to be, where before you may get a total stranger.
Exactly. Now, this also is a little different in that if you receive SSI or SSP or other certain government benefits.
What's SSP?
I knew you were going to ask me that, and I'll be real honest with you. I'm not sure exactally what it is. It's under the Social Security plan.
Right. It has something to do.
SSI is supplemental.
Social Security.
But you can actually get some of the court fees waived. Now, when we're talking about conservatorships, we're talking about the court being involved, whether it's attorneys, there are court costs, and any time that we can, we like to avoid court costs. And that's, again, we'll talk about durable power of attorney. But there may be, for an elder person or somebody that's under SSI, to actually have their fees waived or significantly reduced because of their disability.
Can I comment on the fee situation
for
just a second? In these cases, it's rather interesting because it's not uncommon for an attorney that does this, and they usually kind of have done this type of work for a good period of time.
It's very form intensive, so they better.
Right. But a lot of the times they'll take enough up front to get, I know you talk about it later, the temporary conservatorship, or get things set up in place. But when it comes to the fee, because there'll be an accounting way down the line, they will take the larger fee will come out of the estate itself of the person that's under the conservatorship.
Exactly. It's almost like taking a contingency case, except that it's not an issue of you win or you lose. Well, obviously, if you lose, you'd probably still be out. But this is governed by the probate code. There are schedules that are set up, various percentages depending on the value and the complexity of the case. But yes, a lot of times attorneys will take a case with knowing that they will most likely get paid in the end.
Right. One very interesting thing is, at least in Sacramento, where I practiced for years, is when they appointed somebody for the conservatee, that lawyer would go out and they'd do the thing and they'd represent them as best they could. And they would be paid, if there was an estate, if there was money in the estate, they would be paid their customary hourly fee subject to approval of the court. If not, they would get by the county the reduced rate.
Yes, absolutely correct. And then, of course, I don't think Calaveras is quite set up that way. Every county is a little bit different when you talk about conservatorships, but there's always a hazard in a risk, I should say, for attorneys, because you may submit your bill and whatever amount it is, the court can say, I'm going to approve 50% of it, but nothing more.
Interesting question here, because I practice in Sacramento a lot, and I've been practicing up here. But I notice the structure is totally different. It's the public defender's office is representing the conservatees here, and the DA is doing the prosecution of these cases, whereas in larger cities, county council is. Have you seen some of that?
There's a reason for that.
No.
Because I was elected district attorney in Amador County, I was also the public administrator. So you have to look at, is the district attorney also the public administrator? And that is true.
That's interesting.
Of Calaveras County. Other counties, they have separate offices. The DA, public administrator, you've got a conservatorships office that may be under the DA, may be under county council. But in this county, that's really not an issue you have to worry about, because if you're seeking conservatorship on someone, you need to talk to a lawyer, and the county will, if they've got the public defender or whomever, you'll know as soon as the action is filed. Now, one of the important things is we often hear of, well, they got a conservatorship on me and I didn't even know it. Well, in California, if somebody tries to get a conservatorship on you, you will be notified. It's required. No one can, I don't know of any circumstance where a conservatorship can be gotten on a person that has never been notified, never part of the court action. And even if they did find out, they certainly could oppose it, but there will be notice somewhere.
No, there's a notice. It's due process. You can't lose the rights that you have or turn them over to somebody else to assist you without what's called due process. And if that happens, there's ways to correct that.
Right. Now, in conservatorships, you mentioned temporary. Oftentimes, what the court will issue is temporary orders that are only good for like 30 days. And it may be because something needs to happen within that 30 days, so the court is approving it immediately. But then you may be looking at eventually a long-term conservatorship. Now, what if somebody gets in a car accident and they are completely disabled? You may see a temporary conservatorship, but after 30 or 60 days, they're fine, they're now able to handle their affairs. That conservatorship should go away, just on its own accord.
It's true. It's if you have a temporary conservatorship, if one has been established, say, for a yearly period or something, you'd probably have to go in and seek termination of it.
If it's a longer duration, yes, but
if shorter duration, no, it would just expire by itself.
Right. Now, when it comes down to what the court is going to authorize, again, it's very fact dependent. What does the person need? Do they need a conservatorship of their entire estate, just on their person, or part of what they do as their person? Yes, the financial part, where they live, where they don't live, whether or not they get medical assistance, or who's they're going, what kind of medical assistance they do need. The court literally structures the conservatorship to the needs of the individual. It's not a carte blanche, I want everything. In fact, in some cases, it's real hard to get a full conservatorship where a person controls 100% of everything. There are cases certainly where that is required, but there better be some evidence, whether it's medical or something else, to show the court a full 100% conservatorship is required.
Right. When you see the applications for the temporary conservatorships, they usually have, I think there's maybe a requirement of a certain number of the treating doctors there.
Right.
So there has to be some medical evidence of it.
Right. And then also another important thing is a conservatorship can only be brought in the county where the person resides. That can be a problem. If mom or dad or grandpa, grandma have moved in with you, but they truly reside in the other county, in another county, you may or may not be able to bring the conservatorship here until the residence is changed. Again, talk to a lawyer, make sure you've got the residency issue covered, because if you start an action and you find the court finds that there is no jurisdiction, you get to start all over again.
It was a real interesting question there. Somebody's been living down in, say, Sacramento, and they're brought up here for the sole purpose of you might have a problem with that.
You do. We actually see the jurisdictional requirement in other cases as well, and has nothing to do with conservatorships, but a big issue on jurisdiction is members of the military. What is their home of residence? Where is jurisdiction properly brought? And that may be a state issue. I ran across a case recently where a military person moved to another state, and the state rule was if you're here for 30 days, even if you're in the military, you can bring a legal action there, not necessarily your home of record.
Interesting.
So completely different. Again, when you file these actions, it's a petitioner's responsibility to suggest an appropriate conservator. Now, there may be cases where an action is brought and maybe they have no family members, no close friends, that the court is going to look for input perhaps from the the probate investigator, but generally it's a petitioner, whoever starts the action, to say, I think this certain relative or this friend will do this. And of course, they can't force you to do it. You have to be willing to do this.
No, and I think people need to understand that being somebody's conservator is a huge responsibility.
Exactly.
And it's just huge. And sometimes it might be better to get some assistance with it with the governmental agency, or there are actually people out there who are professional conservators.
Private public conservators, I believe is what it's called. And they're paid to take care of everything. I know one law firm in Sacramento that represents a particular one, and she's got many, many cases. Again, probate law is very form intensive, but between the lawyer and the conservator who does this as a living, they know exactly what they're doing. And I don't know of any up here that are doing that.
No, and they usually, the conservator you'll see that where there's assets in the estate because they'll get paid out of the conservatee's estate, right, subject to court approval.
But if we can, let's avoid having to do conservatorship if at all possible. And there is a way under the law to do that. And when you hear discussions regarding estate planning, this is a part of what we talk about. And I talk to every client when I deal with them regarding wills and trusts about a durable power of attorney, because with the durable power of attorney, they may be able to completely avoid the issue of conservatorship.
You talk about a durable, what is, that's like a living trust. It's one of those terms. What do we mean durable? Does it mean it's like made out of steel instead of rubber?
First of all, it's revocable trust,
okay,
or irrevocable trust.
All right.
Living trust is kind of, in my opinion, is kind of a misnomer. But a durable power of attorney, durable means it's long lasting. Now, for instance, you go buy a car, and one of the many, many forms that you fill out with a car dealership is a power of attorney when you're doing a trade-in. That power of attorney allows them to do whatever paperwork is necessary to get that car out of your name, sell it to somebody else, or perhaps the power of attorney will cover them registering it, the new car, going through DMV. You're giving them authority to act on your behalf, attorney in fact, to do certain acts. And we talk about durable power of attorneys, that's exactly what we're talking about. If I'm incapacitated in the future, not now, in the future, I want these people or this person to be able to do certain things. Same type of things that you would do under conservatorship. But what you're doing is you're planning ahead, saying if the incapacity occurs, I want this person to have this authority.
That's a big decision, and it's so wise to do it ahead of time.
It's a very, very powerful document, and I spend a lot of time talking to clients about what it is, what it can do, and why it's so important. Because you can be incapacitated, and you want that power of attorney to be immediately effective on the incapacity, so somebody can deposit or make withdrawals from your checking account, file your taxes, run your business, do all of the things they can under conservatorship. And with that durable power of attorney, it's effective immediately. You don't have to run off to court. is good to go, as they say in the military.
Right. And I'd urge people to do it because there's a natural tendency to put that kind of thing off.
Exactly. And it also rolls into another area of law, dealing with advanced health care directives. Again, you can avoid a conservatorship. We all know the Karen Quinlan case, that she was on basically tubes and wires for so many years, and her parents had to fight in the court of Florida to stop all of that.
Yes.
But in advanced health care directive, you're saying in advance, if something happens to me and I don't have the capacity to tell somebody this is what I want, it may cover everything from organ donation to burial instructions, your funeral. And of course, you can't go to court and say, I want a conservatorship so I can do all these health care things. Now, if you've got a conservatorship, certainly, yes, you can go in there and say, I need to take care of the medical needs. The problem, of course, is the length of time it takes to get to court.
Right.
And the Advanced Health Care Directive is anticipating all of the health issues, and you're appointing somebody to do what you want because you've got a nice writing saying this is exactly what I want. And two, the person that you've designated has said, I understand what they want and I'm willing to do it. You never designate someone who says, I can't make that decision. And it's a real tough decision. And I talk to husbands and wives about this all the time. You may designate your spouse to be the one to tell a doctor this is what they want. They don't want you to give them a lot of medication. They don't want to be on tubes and hoses if they're in a persistent vegetative state. Your spouse, when it comes down to it, may not be able to make that decision. Obviously, and especially in long-term marriages, that is a very, very, very tough thing to do. I had to do it for a family member. It's very hard to do. So it's better that you put it in writing through Advanced Healthcare Directive. You get your durable power of attorney so that you are saying in advance, this is what I want. And you deliver a copy to your doctor, any hospital that you may end up in. But the Advanced Healthcare Directive, you're authorizing people to say, this is what I want. And you're also authorizing them to be released medical information.
HIPAA.
Exactly. HIPAA requirements. Now, don't ask me what it all stands for.
Okay.
But certainly what it says is you have a right to privacy as to your health issues. And you can sign a release saying, you can talk to my spouse, you can talk to my kids, my neighbors, whoever you put down there, that the doctor can literally talk to those people and tell them, just as if they were talking to you, this is all of the issues that are going on.
Can they do that while you're not incapacitated still? Can you set it up like that?
If you don't have the capacity, you will not be able to do a durable power of attorney or advanced health care directive, because essentially, in order to do those things, you have to have the current capacity to do those. If you don't, now we're talking about conservatorship.
Which is a big difference, yeah.
Absolutely. Certainly, and it takes time. When I say take time to do durable power of attorney, advanced health care directive, I'm talking about depending on how in-depth it is and how many people you want listed. It may take an hour, hour and a half, 2 hours. Conservatorship, we're talking about days, perhaps weeks, maybe a month, maybe two.
And ongoing and ongoing.
Ongoing.
For every little issue.
Exactly. In the law, it always helps to seek legal professional advice if you've got a question. We've often referred to the court's website. You can look there under self-help. State Bar website has a lot of good publications dealing with elder issues. Thank you for joining us.